Hello friends, in the series on the income tax cases, today we will issue a very important case on section 148 proceedings in which the Bombay High Court in a writ petition held that the notice under section 148 cannot be issued to the assessee simply on the basis of the information from the inside portal without verifying by the assessing officer that information, whether that information is correct or not, and some live link between the information received by the assessing officer from the inside portal and the income escapement of the assessee should be established by the assessing officer. The name of the case is Anwar Mohammed Shaikh versus Assistant Commissioner of Income Tax, and this case has been reported in 459 ITR at page number 534. The matter has been decided by Bombay High Court and the date of the judgment is 13th March 2023. In the present case, the assessee has filed his income tax return which was processed under section 143 subsection 1. The assessee has shown in his income the long-term capital gain which is exempt under section 10 subsection 38. The assessee proceedings were completed under section 147, that with section 148, for which some additions were there and the assessee was in appeal. After that, for the same assessment year, that is the assessment year 13-14, the learned assessing officer received the information from the inside portal that the assessee has entered into high value suspicious transactions on the basis of the investigation done by the department. In that information, the assessing officer has also alleged that the assessee is involved in taking fictitious profits in equity and derivatives, and in that notice the assessing officer has shown the same figure two times by adding the same figure of 6.36 crore two times. When the assessee received this notice, the assessee filed return under section 148. The assessee submitted all the documents and objected this notice very strongly. But as usual, the assessing officer rejected the objections of the assessee and go ahead with the assessment. But before completing the assessment, the assessee preferred to challenge this notice by saying that in the present case, the assessing officer has already completed the assessment of the assessee and the reasons do not disclose that what information the assessee has not disclosed in his earlier assessment, because there is a proviso to section 147 which says that if the assessment of the assessee has already been completed in the scrutiny proceedings, then it is the duty of the AO to tell the assessee that this information you have not disclosed, and because of that information your income has escaped from assessment. And the second allegation and the second submission of the assessee was that in issuing the notice, the assessing officer has not verified that information with the return of income of the assessee, and there is no live link of the escapement of the income of the assessee and the information which is there on the inside portal on the basis of which the assessing officer has issued the notice, because the assessing officer has not taken even the heed to verify that information, because the same figure has been added two times while issuing the notice under section 148. When the Bombay High Court heard the writ petition, Bombay High Court said that before issuing the notice, the assessing officer has to put his opinion on record in black and white. It was the point of the Bombay High Court that the reasons are the manifestation of the mind of the assessing officer. In the present case, whatever the reasons have been recorded and whatever the information have been received by the assessing officer from the inside portal does not have any live link, and the allegation of the AO is purely on the basis of surmises and conjectures. So in the present case, when the assessment of the assessee is already completed, the issuing of the notices by taking the same figure two times and without verifying it with the records of the assessee, because the assessee has already shown the income of rupees 6.4 crore into his long-term capital gain exempt under section 10 subsection 38. So the Bombay High Court gave the verdict that in this case, the writ petition of the assessee should be allowed and quashed the second notice under section 148. At the end of this video, once again, I am repeating the name of the case. The name of the case is Anwar Mohammed Shaikh versus Assistant Commissioner of Income Tax and others. And this case has been reported in 459 ITR at page number 534. And the date of the judgment is 13th March 2023. Thank you, friends.